but it's okay for us. So, as Gillian stated, my name is Fabrício Lemos. I'm a PhD candidate at the Federal University of Rio Grande do Sul in Brazil, and I'm here to share with you my thoughts on the ineptitude of international law in addressing inequalities in the making of international law. By the usage of language, we can include or exclude something or someone from rights. This is not a new theme. Critical legal studies, critical race theory, and feminism, for example, just to name a few, all think about how language and concepts are used to include or exclude persons or minorities from rights, and also to perpetuate hegemonical power and political structures. So the main topic I use in my paper is the way international law is made and how the barrier of language is used to exclude thinkers from, especially the global south, from important discussions and decisions on subjects of international law that affects all human beings. This may result in structural injustice because the rules are mostly by English-speaking, which has come to be regarded as lingua franca of international law, as Antia Roberts calls it. We can also see these kinds of inequities in international organizations such as the UN, which not only does not have Portuguese as an official language, but also Brazilian nationals are highly underrepresented in the staff of the organization. In terms of the discipline of international law here in Brazil, the subject has become mandatory only in 1994. However, in the beginning, there was mainly scholars who have been abroad on PhD or postdoc positions in the global north and have returned to teach what we now call mainstream international law. The teaching of the team mostly based in terms of textbooks and from the global north, such as the ones from Shaw or Brownlees. And however, since 2000 or so, there's a new wave of scholars here who are now preoccupied in North-South relations, decolonial thinking, 12 perspectives, and other critical thinking in international law. And because of that, in terms of doctrine, especially in terms of Brazil and Latin America, there's a growing concern on the studying and reading and discussing Latin American and Global South authors. And professors such as Luiz Slava, B.S. Chimney, and Professor Rajagopal, who are, by the way, located in positions in institutions in the Global North, but also professors like Antoni Young, Fabio Morosini, Fernanda Bragato, Michelle Badin, Paola Alvarado, Enrique Pietro Rios, Liliana Obregon, and many others here from Latin America and Brazil. But Brazilians also intend to occupy spaces in the global north, such as this one we're having right now, to raise awareness on other kinds of good scholarly works, such as in international economic law, international trade law, and also on the philosophy of international law. And in terms of international human rights law, I was really glad to see on the panel on climate change that we had earlier mentions on the Inter-American Court of Human Rights and Inter-American Commission on Human Rights, which are important locus of discussions on environmental rights. In terms of Latin America, there's an integrated college of international lawyers who are writing mostly in Spanish and Portuguese, but also in English, on matters of the critical teaching of international law here in Latin America, and also on matters of decolonial thinking and its consequences on the making of international law. There's a group of scholars here called Redial, based on Bogota, Colombia, of highly qualified professors who are able to adequately think in terms of a Latin American perspective on international law. And Latin America has played an important role in terms of economic, social, and cultural rights, and its inclusion on the Universal Declaration of Human Rights, for example. As you may well know, the American Declaration of Human Rights is 8 months older than the Universal Declaration, and the writing of some articles is very similar. The other side of this story is that scholars from the global north are not able to access the works of Latin American international scholars, mainly because of the barrier of language. We as Global South students and professionals are also not able to publish on highly qualified journals because of the barrier of language. Even if we speak English adequately, the grammar structure is different and the academic language in English is far more objective than what Brazilians and other Latin American countries are used to. Since Global North scholars are mainly only English-speaking professionals, and you may well correct me on this one, there's no communication between these two hemispheres of the globe, resulting in a highly unequal, invisible college of global international lawyers. In conclusion, I'm very grateful for being here today to express this concern on what I think it's a necessary issue to discuss with scholars from the global north, such as yourselves. And I emphasize that this is mainly a concern of my concern, and I'm very open on discussing the implications of these ideas with you. I'm looking forward for your comments, questions, and thoughts on this matter, and thanks very much for your time.